Breaking. Ottawa's new law could let CBSA deport you before your appeal. Welcome back to Canada Chronicles. Across Canada, a major immigration proposal is sparking intense debate, one that could change how fairness and due process work in the immigration system. In October 2025, the federal government introduced Bill C-12, officially titled An Act Respecting Certain Measures Relating to the Security of Canada's Borders and the Integrity of the Canadian Immigration System. Ottawa describes the bill as a modernization effort to strengthen border security, fight organized crime, and improve efficiency. But immigration lawyers and civil rights advocates warn that, depending on how it's implemented, it could also limit hearings, reduce appeal protections, and give the government sweeping new powers over immigration status. In this investigation, we'll break down what Bill C-12 actually says, what critics fear it could lead to, and why experts call it one of the most significant immigration reforms in recent years. Stay tuned until the end, when we explore the deport before appeal scenario, a realistic look at how these changes could work in practice and why it's causing concern among immigration advocates. Before we begin, make sure to subscribe to Canada Chronicles and turn on notifications so you never miss our latest deep dives into the policies shaping your future in Canada. Let's get started. A quiet power shift in Canada's immigration system. Bill C-12 was tabled in Parliament on October 8, 2025, as part of a broader package to modernize border and immigration enforcement. The government says the bill is about improving security and efficiency in response to growing migration pressures, fraudulent applications, and organized crime networks. If passed, the legislation would expand the powers of the Canada Border Services Agency and the Minister of Immigration, Refugees, and Citizenship, allowing them to take faster action in what they define as the public interest. While supporters describe the bill as necessary modernization, critics argue it may mark a shift towards stronger executive control over immigration decisions, raising questions about transparency and fairness. What's actually in Bill C-12? According to the text tabled in Parliament in government summaries, Bill C-12 would allow the federal cabinet to cancel, suspend, or modify immigration documents, such as work permits, study permits, and permanent resident cards if doing so is considered to serve the public interest. Shorten or change procedures for asylum claims, particularly for people who have been in Canada longer than 1 year without submitting a claim. Give the Canada Border Services Agency expanded operational powers, including access to transportation hubs, storage facilities, and data sharing with law enforcement partners. Combine immigration oversight with border security and intelligence operations under a single legislative framework. The government says these changes would help it respond more effectively to fraud and national security risks. Legal experts agree the bill would streamline enforcement, but they caution that the broad definition of public interest could enable discretionary decisions with limited oversight. The government's rationale. Public Safety Minister Dominic LeBlanc has said Bill C-12 will modernize the way we secure our borders while maintaining fairness. Officials point to cases of fake admission letters, ghost consultants, and human trafficking operations as proof that stronger tools are needed. Ottawa maintains that decisions made under the new powers would still respect Canada's Charter of Rights and Freedoms and international commitments. It also says any document suspensions or cancellations would occur only under exceptional circumstances. Supporters within government argue that Canadians are losing confidence in an overloaded system that now manages millions of active files. They say modernization is essential to protect both efficiency and integrity. Why critics are concerned. Immigration and human rights organizations, including Amnesty International Canada and the Canadian Civil Liberties Association, have warned that Bill C-12 could weaken long-standing procedural safeguards. One of their main concerns involves appeal rights. Under Canada's current law, people ordered removed from the country usually have the right to remain while appealing. Critics fear that, once regulations are finalized, some categories of applicants or refugee claimants could lose that automatic protection. While the bill itself doesn't eliminate appeals outright, it creates a legal foundation that could allow faster removals in the future. Something opponents describe as a move toward a deport first, appeal later model. The government insists safeguards remain in place, including access to judicial review. But those reviews can take months, and critics argue that if removals happen first, justice may come too late to matter. Who could be affected? The potential impact depends on how the bill is implemented. If passed without significant amendments, it could affect temporary foreign workers and international students if their employer or educational institution is found non-compliant. Even those who followed every rule might face permit suspensions if entire program categories are frozen. Permanent residents if the cabinet exercises the new authority to suspend or cancel documents in a declared public interest situation. Refugee claimants who file late or under irregular circumstances, as they might no longer be entitled to a full hearing. Employers and educational institutions that rely heavily on foreign workers and students, potentially facing staff or enrollment shortages if sudden suspensions occur. Amnesty International Canada says these powers could inadvertently harm people who have complied fully with immigration laws, describing them as collective penalties that risk punishing the innocent alongside the guilty. Expert reactions. The Canadian Immigration Lawyers Association has filed formal submissions calling for amendments to limit the bill's discretionary scope. Its president, Bashir Khan, said, "Efficiency cannot come at the cost of justice. Once a person is removed, even if an appeal later succeeds, the harm is irreversible." Academic experts, including Professor Audrey Macklin of the University of Toronto, have also warned that framing immigration primarily as a security issue risks normalizing emergency powers in everyday cases, something Canada should avoid. Thanks for staying with us this far. We appreciate your time and hope you're finding this information valuable. The deport before appeal scenario. To understand the concerns, consider how this could work if the law passes as written. Imagine the Canada Border Services Agency identifies a group of students linked to a college under investigation for fraud. The Minister of Immigration invokes Bill C-12's new authority to suspend all related study permits in the public interest. Overnight, those students lose legal status in Canada. Under current law, they would likely be allowed to appeal and stay until a decision is made. Under the new framework, however, that protection might not be automatic. Deportation orders could be issued immediately, and by the time the federal court reviews the case, those individuals could already have been removed. Critics say this is exactly why safeguards matter, because due process after the fact isn't true justice. The economic and human impact. Beyond the legal debate, the bill could have ripple effects throughout Canada's economy and society. Industries such as healthcare, construction, agriculture, hospitality, and food processing rely heavily on temporary foreign workers and permanent residents to fill critical labor shortages. Any mass suspension of permits could disrupt services, delay projects, and increase costs. The education sector could also face challenges. International students contribute more than $22 billion annually, and sudden enforcement actions could leave hundreds stranded through no fault of their own. For families, the stakes are deeply personal. A sudden suspension of permanent resident cards or sponsorship files could separate loved ones for years. Perhaps the biggest consequence, experts say, would be public trust. Canada's immigration system depends on predictability. If rules can change overnight, confidence in the system erodes. What happens next? As of November 2025, Bill C-12 is still being studied by a parliamentary committee. Hearings are scheduled before the end of the year, with amendments expected. Multiple organizations, from universities to labor unions and legal associations, are submitting feedback urging stronger oversight and clear limits on ministerial powers. Even if Parliament passes the bill, the specific regulations defining how and when these powers can be used will determine its real-world impact. Those regulations have not yet been made public. How to stay protected. While the debate continues, individuals can take steps to protect themselves. 1. Keep copies of all immigration records and communications. 2. Renew permits early and ensure no gaps in legal status. 3. Follow official updates from Immigration, Refugees, and Citizenship Canada and the Canada Border Services Agency. 4. Confirm that your school or employer remains compliant with federal requirements. 5. Seek advice from licensed immigration lawyers or consultants. 6. Participate in public consultations when the government releases draft regulations. Preparation and awareness are the best defense in a system undergoing rapid change. Balancing security and fairness. Bill C-12 highlights a difficult balance for Canada, protecting national security while maintaining fairness and compassion. Supporters see it as a long overdue modernization that will help Canada respond quickly to fraud and exploitation. Critics fear it risks giving government agencies powers that could undermine the country's long-standing commitment to due process. What everyone agrees on is that the details and how they are applied will matter most. The legislation's final shape will determine whether Canada strengthens both security and justice or sacrifices one in the name of the other. In the end, Bill C-12 is more than just another immigration proposal. It's a test of Canada's values. Supporters see modernization and safety. Critics see potential overreach. The outcome will decide not only how Canada protects its borders, but how it defines fairness for everyone who seeks to build a life here. If you found this breakdown helpful, don't forget to like this video, subscribe to Canada Chronicles, and turn on notifications so you never miss our latest updates on immigration and life in Canada. Thanks for watching. See you in the next video.